Good evening, everyone. I was about to say good morning, but we're just on the brink. So good evening, everyone. Welcome back to another session of the AI Week series. I open-heartedly hope that you've been enjoying what you've been seeing so far. We had some great responses from you in our previous sessions. We hope that you continue to participate in today's session. Just to remind you, that's using either the Q&A function to ask a question or just pop a comment in the chat. Both of them are welcome. And today with me, I've got Stavrola, who will be talking about intellectual property in AI, a very interesting topic. We spoke about it quite a lot previously, but without further ado, would you like to take it away?
Yes, thank you so much, Christian, and thank you for inviting me. So I do understand that you are all somehow familiar with a lot of artificial intelligence tools. Probably you do not know the legal background and the legal framework that is governing artificial intelligence. Currently, as we will be discussing, there are no laws that specifically tackle artificial intelligence in the UK, but there is an ongoing discussion the UK Intellectual Property Office has launched a consultation fairly recently about a discussion on how AI can be accommodated by the current intellectual property laws. So the plan of my presentation today is to give you a rough outline on intellectual property, to give you an overview of legal areas that can cover artificial intelligence, and if so, to what extent, and also to look at challenges and specific issues that pertain to artificial intelligence and intellectual property. So in terms of the outline of what I'm planning to discuss today, first I will offer you a definition of intellectual property law. Clearly, if you have any questions as I talk, you are very welcome to interrupt by asking any questions on the chat box or the Q&A forum. I will be following that hopefully, and I will be able to respond to ad hoc questions. Then I will start talking about how artificial intelligence challenges intellectual property law. You should know that all of this discussion is fairly recent, at least in the area of intellectual property law, because firstly, these are new technologies, but this is not the only reason. There are ways in which artificial intelligence becomes the more and more challenging with regards to how the law can cope. And a number of questions have been raised as well at the legislative level on whether we need to revise current laws in order to facilitate artificial intelligence or accommodate certain activities that are beneficial for the public interest. And there are certain legally challenging questions that I would like to focus on, because I understand many of you might also be engaged into the development of artificial intelligence or have ideas about applications that might be using artificial intelligence. So one of these questions is, can artificial intelligence machines create and perhaps even own intellectual property rights? Can artificial intelligence infringe intellectual property rights of others? And if so, how can this take place? And also, what are the available uses that are permitted by intellectual property laws that could be accommodated easily under the current legal framework? And also, finally, do we really need new intellectual property laws? So starting by a definition of intellectual property is an overarching term used to refer to industrial property as well as copyright, the so-called intellectual property per se in some jurisdiction. And it is, as some authors have said, an amorphous bundle of rights. So effectively, we have a number of rights that can be generated and can be falling under the umbrella of intellectual property rights. These include copyright, which protects artistic, literary, dramatic works, musical works. It can include patents, trademarks, designs, and so on. And what brings all of these together to some is that they are all creations of the mind. They are all ideas that take a particular form, and hence the way in which they are expressed deserves protection. So this gives you here an outline of the forms of intellectual property. Intellectual property is a form of knowledge, and everything that is generated under intellectual property laws is knowledge that is worth protecting in the particular way in which it has been expressed. So we do have patents that protect useful ideas. This can cover from computer programs in some jurisdictions to genes and the development of gene patents, to medicine, or even to specific applications that are sufficiently innovative to attract patent law protection. We have copyright, which protects original expressions of certain ideas. And that could be works of art, that could be films, broadcasts, musical works, dramatic works like dance or mime, and so on. Then we have trademarks. These are distinctive identities that are usually attached to products, but it does not have to be something that will be attached to products. From Coca-Cola to KFC and to other distinctive identities, we speak about certain names or certain figurative marks that will identify goods and services that are available in the market. And for everyone who is about to embark into an enterprise and a business, this is something that will be probably the starting point, how to identify the goods and services that they are going to launch in the market, how they are going to distinguish themselves in the marketplace. And then we have designs. We speak again about distinctive identities, but these are going to have a physical application, because here we speak about goods that take a particular shape, and because of the shape that they take, they receive protection just on the shape of specific goods. So these are some basic intellectual property rights. We do have some other sub rights under intellectual property law, and they can include, for instance, breach of confidentiality. Confidentiality is also something that intellectual property laws protect. Again, in terms of the subject matter of protection, I'm giving you here a rough outline of the criteria of protection, and I'm offering this outline because I would like you to reflect on how AI can be a challenge. What is it that AI can do in order to impact on intellectual property and the way in which the law applies? So for trademarks, as I told you, we have distinctive identities, badges that indicate the origin of goods or services. When you buy a Coca-Cola can, you do not know exactly how it will taste from jurisdiction to jurisdiction. It does not taste the same everywhere, but you know that this is something that is branded by the Coca-Cola company, and you put some trust into the fact that you will probably be drinking Coca-Cola. Then when we speak about industrial designs, we speak about the look and shape of products, from the shape of cars to the shape of everyday objects like the mug that Christian just used to drink his coffee. Everything like that can be design protected. When we speak about distinctiveness as a criterion for protection for trademarks and industrial designs, AI can be challenging in the sense that it can collect information on specific products, and then it can use them for personalized and targeted advertisements. You have all seen how frequently you are targeted when you are searching things online. This is not just cookies. Sometimes it is machine learning. It is about understanding what you buy, what you are interested in, and then getting in touch with you by algorithms that identify your needs and your wishes on things to buy. And then this is something that is AI generated through machine learning algorithms. They can even predict what is the next thing that you would probably be interested in buying. When we speak about patents, we speak about inventions, and in particular, we speak about useful ideas that are applied to industrial products or processes. So this can include medicine, including now the vaccine for COVID-19. This is also something that is patent protected, very controversial as to why public health should not be free, and there has to be patent protection included. But here what is protected is novelty, something that is new, something that has never been done, and then non-obviousness, something that someone who's an expert in the field would not consider to be obvious, that anyone who's an expert in the field would be able to produce. So again, here AI, something that can create inventions. If an AI algorithm is fed with enough information, probably from patents that have already been published, can it actually create new inventions? And if so, how? And again, a question that has to be asked here is the level of human intervention. And this is something that is currently discussed at the legislative level. If there is a human that is operating the algorithm and sets all of the instructions, it is far more likely that patent law protection can be granted because this is something that requires some intervention by a human. But there are certain algorithms, especially those that are operated under machine learning tools, that actually learn to do things by themselves. What happens in those cases? These are open questions. I'm sorry, I'm not going to have answers to all of the questions that will be asked today, but I hope I will be able to engage you into a discussion, into thinking about AI and the way in which it currently is legally protected, but also legally challenging. And then finally, with copyright law, what we protect under copyright law is an original expression of ideas, someone who writes a poem, someone who writes some music, someone who performs music, or film artists and actors. All of this is artistic and creative activity that is protected by copyright law insofar as the works that are produced are original. And under the European Union standard, which has been introduced into UK law as well, a work will be original when it is its author's own intellectual creation. It is the author's own intellectual creation. So for a work to be original under copyright law, for a music work to be original under copyright law, we need to have a human author according to current law. Of course, there is a peculiarity, let's say, something very idiomatic to UK copyright law, according to which computer-generated works that are generated by computer algorithms can also attract protection, and the protection is going to be owned by the person who has developed the computer algorithm. Again, a human intervention is included there. But I'm sure that many of you have seen that there are a number of applications out there at the moment that use artificial intelligence that can create new musical works. They can randomly generate poems with artificial intelligence. They can even have Elvis, bring Elvis back from the dead to sing some new songs. And at the same time, as we will be seeing, there are artistic works that are created purely with algorithms and artificial intelligence tools. This is the era of deepfakes, an era that is affecting tremendously copyright laws, because there are going to be a lot of artistic works, like a work of Picasso that has never been created by Picasso, but by artificial intelligence algorithms, say that someone who is not a scientist with good intentions in developing wonderful artificial intelligence tools, but someone who wants to make a profit creates a Picasso and it is introduced out of nowhere. What happens about that? There was a discussion a couple of years ago about James Dean and bringing James Dean in order to roll a new movie, so that this is an era of deepfakes. What about performance rights there? There are a lot of questions that can be had with regards to copyright law and whether AI can create intellectual property or whether it can also infringe it. Yes, Christian, you had a question?
I actually do have a question here. So, I understand if the law isn't developed in this, and I think that's something that all of the, especially students right now who will become future practitioners, should watch out for. So, granted that if you have an algorithm that creates something, the copyright laws now belong to the developer essentially. What if you have and this is related to me, what if you have a piece of software that uses an algorithm, but then it's a human using that algorithm to develop something? So for example, a lot of artists will draw. I hope I'm not adding another layer of complexity to this, if that makes sense, but that's something that is going on right now. There are obviously algorithms that assist people in doing various things. Who does the copyright go to in those circumstances?
Okay, so I understand. Okay, I can think of an example of what Christian just mentioned. Probably many of you have seen on Facebook, there are all of these applications that can help you see how you would look like if you were a Hollywood star, how you would look like if you were 50 years older, and so on. The software developer who has created this tool holds copyright on the software that they have developed. Under United States intellectual property laws, they will also have patent protection over the software. This is a bit subtle, so just keep in mind, it is something that is mostly for lawyers to reflect on, but under European Union law, software is mostly protected by copyright. It is going to be protected by patent law in addition to copyright in very, very limited instances. So it is a little tricky to explain all of this now, but under United States intellectual property law, there can be both copyright protection and patent law protection, which will make it even stronger for the protection for the intellectual property developer of the software. But when it comes to the people who are inserting their own images, let's say, to the algorithm, they're feeding the algorithm with their own images, then it is much more likely that they will get themselves some intellectual property protection over the output of the algorithm. And I'll give you an example. I don't know, Christian, last time we spoke, I showed you that painting and incidentally it's behind me again. I forgot about it, I have to say. It's random, probably have to remove this. Sorry, guys. I don't know if you see this painting behind me. So this is a painting that has been created through artificial intelligence. I don't really like it, but my husband got it. And I find it very interesting from an IP perspective. So I thought it is a good example every time I'm talking about AI and IP. So there is a software developer who has created it. He has created an application that is currently available to buy on iTunes. And through this application, you can then create your own pieces of work of art. But in addition to developing this software, we speak about a developer that used to be working with Google and SanDisk in the past. And he was in California for many years. Then he came in the UK. Then we've been at one of his exhibitions. And this is something that he created himself using his own software that is available for you to buy as well. But at the same time, he also created the paintings and he exhibited them. So he holds copyright protection on both the software that he's commercially exploiting at the moment via iTunes, but at the same time, he has the intellectual property rights over artistic works such as this one. So this is a possibility of having two copyrights, let's say, over something, over the same output at the end of the day, and it can belong to different people. In this occasion, it belongs to the same person. We just own the 3D printed output of that technical, not so artistic exercise, and it is raising a lot of interesting questions in that regard.
Yeah, so we actually have a question from a member of the audience. So Paul asks, what about works of art which are generally geometric patterns? And I think he adds to it stochastic or random variables as part of the algorithm. I'm not entirely sure about stochastic variables, but
I probably do not know what that is as well. Let me go on the chat box. All right. So what about works of art which are generally geometric patterns? What about stochastic? That's Greek. Or random variables as part of the algorithm. So there are two different things. When we speak about geometric patterns, in terms of geometric patterns, they can be in principle protected under copyright law if they are sufficiently original. But then when we speak about variables in terms of an algorithm, again, if it is sufficiently original, that could qualify for protection under as a software under copyright laws, and that is under the laws in the UK. So one of the things that is quite important to bear in mind is that intellectual property rights are territorial. They will differ from jurisdiction to jurisdiction. For now, we can safely assume that EU laws will be more or less applicable in the UK as well, and for some time, but I would expect that there might be some changes now that Brexit has happened from now on. So at least in the UK, protection would cover currently copyright works that are their author's own intellectual creation, including geometrical patterns or algorithms insofar as they are original in a copyright sense. So just to carry on with a little bit of an overview, I think I have the time to do that. IP, intellectual property rights, are not necessarily a right to do anything whatsoever. What someone has to do is to create a work or to invent a patent or to find a distinctive identity for their goods and services, and wait for someone to carry on with an act of infringement. Effectively, someone that has created a new work or a new invention, they will just have to wait for infringement to take place. And of course, we speak about rights that are limited in terms of their duration and scope, but at the same time, rights that have a territorial nature, despite the fact that there have been some harmonization processes. I'm not going to go through the scope of rights now. This is just to give you a rough outline of how long each right lasts. These are more technical aspects, but I will give my slides to Christian afterwards to share with you. In terms of rights, one of the things that is also worth considering is that some of the rights are rights that you have to register in order to get protection, but some other rights exist automatically, like copyright. The moment that you write an essay, you get copyright protection for it. The moment that you devise a tune and this tune is recorded somehow, again, you get copyright protection on it. And then if you design an algorithm, again, you get protection without having to do something in order to protect it. These are rights that exist automatically, but other rights like patents and trademarks, you actually have to register them and you have to pay in order to renew registration. So this is just to indicate that there are certain rights that might exist without us even paying attention to what we have created. And again, this is an outline of where registration takes place and also whether there are examination processes in place. This is a little bit more technical. I would like not to focus too much on that, but this is something worth reflecting on. If you yourselves create at some point intellectual property, it might give you an indication. same here. So, okay, how does AI challenge IP law? We have already seen some of the instances. One question is, can AI machines create intellectual property? And say that they do, can they own it? These are questions on which I might not be able to give you a straight answer because it all depends on the way in which AI is generated in every case. And in addition to that, there are questions that are again open questions, in the sense that the current laws might not specifically address AI instances. One of the things you should know is that when we speak about AI technologies, it is not necessary that new laws will necessarily be needed to address AI. It is about how the current laws will be interpreted with regards to AI by the courts. And sometimes the current laws will be sufficient and there will not be any need of changing the laws. It will be a matter of having a court addressing specific issues. In terms of infringement, can AI infringe intellectual property? So when someone is developing an AI algorithm, could they themselves be breaching any laws? This is another question. And especially for those who are engaged in AI activities, this is a quite interesting question, because they might be breaching laws without even necessarily understanding that they do. And again, which are the uses that are permitted? And anyone who's developing AI algorithms can rely on in order to produce AI works or inventions. So in terms of the question, can AI machines create or own intellectual property? I'm giving you the example of the new Rembrandt. This is a painting that was created a few years ago, and it was developed by AI tools. In particular, there was a Dutch lab with many scientists who worked together. They incorporated into the algorithm plenty of works of Rembrandt, and they identified some common threads on the basis of these data mining, as they call them, techniques. So they introduced into the algorithm all of the works of Rembrandt, and then the algorithm came back with the result that there should be the portrait of a male nobleman who should be wearing a white collar, who should be in roughly that kind of age. And this is a painting that was created entirely by artificial intelligence tools. It was printed through 3D printing tools in order to regenerate the specific technique in which Rembrandt would have painted this work had he lived now, currently. And if someone would see it, they would have probably thought that this is an original Rembrandt. I'm giving you also here a link to the video that explains exactly the process of how the next Rembrandt was created. This alerts us to a number of possibilities. Clearly, the scientists that developed the algorithm had intellectual property over the software, but what about the output? Dutch law follows the European Union model, according to which there is no protection afforded to computer-generated works, meaning the output, the final output, is not under copyright protection. In the UK, my answer would have probably been different, because computer-generated works are protected by copyright, both in the UK and in Ireland. But this is just flagging up a number of issues, questions about deepfakes, questions about the way in which works can be produced in a way that possibly can now create human authorship, make human authorship, render it meaningless. There are a lot of questions on that. And this is the painting of Edmond Bellamy. This was printed on canvas, and this is a work that belongs to a number of generative images that were developed through artificial intelligence. It is signed with part of the algorithm that was used in order to create it. And when we speak about this kind of generative piece of artwork that is created through artificial intelligence, this was surprisingly sold by Christie's for almost $500,000. This was considered an amazing victory for AI artistic creativity. And then again, you probably are familiar with Google Clips. It was discontinued a couple of years ago. I don't know why, but Google Clips is a camera that takes random pictures, but has a machine learning algorithm embedded that can understand which pictures are meaningful and which pictures are not meaningful. What about originality, and what about the films that it creates? Who owns the copyright? Is it Google? Is the person who's using the camera? Where do all of these images get stored? There are a number of open questions when it comes to AI, and here it is a matter of this camera being in a position to identify what is meaningful and what is not meaningful. This is the machine learning algorithm that is embedded, that learns what is important and what is not so important. And going to the world of patents, a number of information of everything that we do is stored from our fitness trackers to the plugs that we use, that some of them might be smart plugs from Alexa. All of these things involve patents. At least most of them are developed in the United States. But what happens in terms of ownership of the information that is used in order for the algorithms to improve further? So we speak here again about instances where it is not entirely clear about who owns or who should own the rights that can be created under inventions as well. And there are a lot of questions, especially when we speak about AI-generated patents, about privacy. It has been said, for instance, that new consumption trends in electricity will be monitored by the plugs that we have at our houses. The moment that they become smart plugs, there will be information that will be sent to the developers of these plugs or whoever else will own the relevant intellectual property rights, and they will understand how many people live in every household, how much they live at home, which are the rooms that they use. They will be able to calculate exactly how much electricity we have used, and so on. And this goes to all of the activities, and especially with fitness trackers. There is a lot of discussion these days about there are a lot of patents on fitness trackers and these kinds of machines, and most of them will be able to work with artificial intelligence in order to improve the healthcare of whoever wears them. But what happens to the data that is generated through them? There are a lot of questions. Do they belong to the person that uses the fitness tracker? Do they get recorded by the company who is selling the fitness tracker? There was a discussion in the past about making this data a commodity somehow. And if someone wants to get a fitness tracker cheaper, or to benefit from some of these devices that gather data, to sell data instead of spending money on buying a particular machine or equipment. So that was part of the discussion. I'm sorry, my daughter showed you something she's creating. All right. So now going on, yes, Christian, before I move on.
Yes, so we've got another question from Paul. And he asks, can this be broken down? For example, input data to enable the learning and or AI method, for example, deep learning neural network or specific architecture of the neural network. Example, number of layers and activation functions or value parameters important to the implementation of the algorithm. That's a way too complicated question for me.
It is too technical for me too, I have to say. Input data to enable learning. Yes, of course, when data is inserted, we speak about information and then the AI method. Of course, when we speak about intellectual property, we speak usually about overlapping rights. So it is quite important that we know exactly how an algorithm will be used, or how a final product using AI will be used in order to understand exactly what is it that can attract protection and then how. So it is about understanding all of these aspects and understanding. Okay. Okay.
And there's a follow-up. So Paul asks, the algorithm cannot learn without data. So who owns the data, and do they have rights?
This is a fantastic question, Paul. It is an open question. It all depends on the kind of service. It all depends, as I said, because some of the data could be personal data. And this raises a lot of questions on privacy and on data protection, especially under the GDPR framework that was created in Europe 2-3 years ago. This is going to be quite an issue about personal data that is used by algorithms. So when a company, an AI developer, wants to use data in order to enhance machine learning algorithms, then they have to be sure that if any information that pertains to individuals is included, and sometimes this is relevant, then they have to be sure that consent by the individuals has been given, or at least that no data protection laws are breached. And this is an issue. And this is why there are a lot of discussions about changing intellectual property laws in order to accommodate more artificial intelligence, especially to the level that it can promote our welfare and it can be in the public interest for it to be protected. This is the reason why there are all of these discussions, and we do not speak about proprietary entitlements of the people who have initially generated data. And one of the things that is quite relevant here, and this brings me to infringement as well. This links very well to what I had to say now, this question of Paul. As Paul said, AI and machine learning tools, they need data in order to function. The more the data, the better they will work. Consider Google, for instance. I'm sure many of you will know the Google Books service. Google Books is a service that has scanned and digitized millions of books at worldwide level. And they did not just scan it and digitized, they have also OCR'd the books so that they have access on a word by word basis on everything that is written within those works. This has given Google tremendous power in terms of developing its own algorithms, because they do now have knowledge that is included in millions of books. And with other agreements, they also had plans to digitize multiple patents as well and OCR them as well. So all of that is part of Google's know-how and a reason why the algorithms are getting the better and better. Of course, there are questions like, can AI machines infringe by getting access to this data? The answer is that in principle, yes, they can infringe. They can infringe both copyright laws or patent laws. So usually infringement occurs when someone copies the works of others. And this happens without getting permission or a license. And also there is no defense to allow this kind of use. And at the same time, there might be breaches on data protection laws. when we have information that could be linked back to individuals. So in all of these cases, we speak about possible infringement of intellectual property rights and also data protection laws. And in cases like that, there could be additional kinds of protections available, such as negligence or contract or tort. Yes, Christian.
So we've got so many more questions coming. I think we've hit a vein, like a golden vein there with questions. A lot of people very interested in whether their work will infringe rights or not. So the first one comes from Anya, who has asked, and I'd be interested in this one as I've got a watch myself that is exactly like that. For the data gathered in fitness watches, would the data be considered to be created by the user of the watch or the designer of the watch? So that's the first question, and we've got follow up on.
Yes, Anya, yes, the data is created by the user, but the user might not always hold a file of all of the information that is retained of him. These data may be monitored by the fitness tracker company. And what this company does with this information, they can be in breach of data protection laws, especially if in some way it is possible to go back to the individual who is wearing the fitness tracker. So a number of issues could emerge when it comes to that.
And then another question, that one that comes from Angela. If the algorithm can use public data, for example, books, to create something for the developer, i.e. an individual person, can that developer still have a copyright on that product? That's the first part. Yeah, actually, that's the question.
Yes, as a matter of fact, they can. When an algorithm is using information, well, usually an algorithm will be much better if it uses a lot of information, especially a machine learning algorithm. The output could be developing new knowledge, and it could be attracting new copyright protection on its own right. And I'm coming to that in a moment about data mining and text mining techniques. So there might be an algorithm that uses information from various sources, and then the output of that process being in a position to attract its own copyright protection. Just to give you an example, there have been companies that have been using medical information, including articles that have been written by doctors, by biologists, by health specialists, and sometimes also anonymized medical data. And they have been able to identify, on the basis of the research they carried out, that a specific drug has side effects with regards to certain users. Or they might have been able to find a new use of an old medicine. And that is on the basis of artificial intelligence tools. This is knowledge that can itself attract copyright protection, yes. And I see that Angela follows up and says, if the algorithm can use public data,
That's the same.
it's the same question. Yes, they can use public data. If the data is public, then it won't be an infringement of copyright laws or any other database laws, data protection laws, sorry.
Great questions, by the way, guys. Well done. Yeah.
So another question is about, just to give you an indication here, does the use of artificial intelligence tools to recreate works such as Van Gogh's Starry Night amount to copyright infringement? In principle, yes, because Van Gogh's work is still under copyright law. This is again something that is not in the public domain, but going back to Angela's question, would the use of artificial intelligence in order to recreate Mona Lisa, which is not subject to copyright protection anymore, that would probably be a case that could amount to, that would not amount to copyright infringement, because this is something that is available for the public to use. Okay, hold on. And what I wanted to say, by reference also to Angela's question, is whether there are permitted uses, whether some uses are permitted by copyright. Recently, the laws in the UK, that is in 2014, have changed to allow data mining techniques on certain conditions, of course, including that the use is not going to be a commercial use. So they allow now researchers to mine information for the purposes of non-commercial research in order to develop new knowledge. And this is something that has benefited tremendously universities that use AI tools in order to produce new knowledge. But this is not something that, at least in the UK, applies at a commercial scale, and this limits to a large extent what companies can do without getting licenses. So someone who's about to use the final output of their artificial intelligence engagement, they will probably need to clear licenses unless they do not, they want to leave this work that they have themselves created free for everyone to use. So there is a specific exception that is available under UK copyright law, not patent law, not trademark law. This is something limited, as you will see, that allows data mining tools in the UK on the basis that this is going to be addressed for non-commercial research. But much of it has to be licensed. This is why the United States is a paradise for artificial intelligence at the moment. The laws are far more permissive towards technological transformations. Google Books that I've mentioned earlier is something that has been subject to ongoing trial for more than 10 years with the Authors Guild Association in the United States. We have had a number of rulings, and despite the fact that we probably had the most prominent copyright infringement in the history of copyright law in the world, this is something that was found to be permitted under the United States fair use test, something that would have never been deemed permissible in the European Union or the UK. It would have been the most paradigmatic example of copyright infringement in Europe and in the United Kingdom. And one of the problems, and I have written 2 books on that. One is on mass digitization projects and the way in which machine learning can be used when we have big bulks of text at our disposal, and also about defenses to infringement. What happens about companies that engage into this kind of creativity that uses technology at its core? Can it be permitted? Can it not? The framework in the UK, but also Europe, is very restrictive at the moment, to the effect that we cannot speak about true opportunities to innovate on AI unless someone wants to pay for what they have created in order to get the content and develop the algorithm. So in case you are interested, we have submitted a consultation to the UK Intellectual Property Office about how the law can change in some regards. As lawyers, we are not always so keen about changing the law on every technological development, but there are certain aspects that could actually be helpful. This is the document that I'm talking about. In case you are interested, I can share that with you. And that's more or less from me, but I would be very happy to receive any questions that you have. And I think that there are probably a couple.
Yeah, I mean, we can give a few seconds for anyone that has any questions. Please pop them in the chat now. I think we've got that's a very, very bold question from Angela there. She asks, can we purchase your book anywhere? That's a compliment if I've ever heard one.
Thanks. Yes, it is available. You can also check on my profile, because I think that students might have access via the library as well. So you can purchase the book, of course, via Amazon or the publisher Oxford University Press. But I think the book will also be available from the university library as well.
Okay, and then we've got another question. Please open up a chat because that one is a long one. And Paul is notorious for very technical questions, I've now noticed.
I know, I love them.
So a new AI algorithm is a new knowledge and advances theory, and there is lots of academic publications with new algorithms. What constitutes a new algorithm? Google Books? Question mark.
Well, with Google Books, we speak about a project that just collected information. We do not know what Google has done with it. I do not know what Google has done with it. Probably the algorithms might have been created. Oh, okay.
Oh.
Sorry. So, okay, yes, AI algorithms are new knowledge and they can attract protection on their own right. Okay, there is lots of academic publications with new algorithms. What constitutes a new algorithm? It will all depend. Usually when we speak about copyright law protection, we speak about something that will be original and the threshold is fairly low. So when we speak about intellectual property algorithms, we will say something that is the author's own intellectual creation, something that has not been subject to copying from someone else. If someone is able to create something similar, but they do that independently, then this can also attract copyright protection.
Okay, that's fantastic. So we've got a couple more questions. So first of all, Angela, that one is for me, I believe. So she's saying she's sorry that she's asking so many questions. I'm going to put this out there now. Never apologize for asking questions. I think that's a great trait. And she's asking when or where she can access the Zoom recording. I will distribute that next week. Starting Monday, we'll be editing all the Zoom recordings and we'll be distributing it to our attendees. So do not fear, I will distribute that to you. That will be announced through the email. And then we've got another question from Karina. What protection is there for small companies for intellectual property? They may not be able to afford worldwide protection like large companies can. A very good question as well.
Well, it all depends. This is a very good question. Yes, it all depends on the kind of intellectual property rights that a smaller company is after. If it is about copyright protection, it costs nothing to develop something new in terms of copyright law. So designing an algorithm as such is not something that will attract on its own copyright. Just give me a second. I will be back in a moment. Sorry.
If you want to pull any other questions into the chat, please do. I think this is a great opportunity to plug the remaining 2 talks. So I'm going to do that now. So yeah, whilst you were away, I was just plugging our remaining talks.
Yes, I can hear it.
So we'll go back to the questions, but just so you know, and just so I don't have to do it later, tomorrow are the 2 remaining talks for AI Week. One of them is by Carmen Ventre. He will talk about the research and academic perspective on AI and finance, much like the talk that we had yesterday by FBN Bank, so don't miss that. And following Carmen's talk, there's a talk by Gustavo Pereira from Spotify, who'll be talking about advanced clustering, customer clustering techniques in AI. So he'll be talking, he's a very hands-on person, so that will be an amazing talk. So we welcome you all there. Back to the questions before we break up.
I have to respond to this question of Corina, because I think this is a very interesting question, especially for startup companies. I think this is going to be something extremely relevant. Smaller companies, when they create a new copyright, because that might be including a new algorithm, a new AI algorithm, let's say, or they're trying to trial it, this is something that they can do without any cost. Because copyright emerges automatically, does not need registration, there is no problem at all with that. But when it comes to patenting some invention, this will generate immediately costs. This will be something that will cost a lot, not necessarily immediately, but for the first 2 or 3 years, after the first 2 years of the patent, it will start, the cost is starting to accumulate, and it is something that can be extremely costly, especially when we speak at an international level. The same applies to trademarks, because as I told you, protection is territorial, and the moment that we have territorial protection, it means that someone has to buy rights in every jurisdiction that they want to get protection. So that immediately raises the cost. What small companies do, if they have something extremely innovative, they have the practical way around it is usually to have a lot of trade secret protection. Keep information free, sign confidentiality agreements with other companies in order to start finding investors. And this is how they go around it. So they play around trade secret and confidentiality laws, and they have trade secret confidentiality agreements with companies in order to identify what is relevant. This is how they go about it. So they do not just patent things themselves, because that will be immediately a high cost. They do not even necessarily have to apply for trademarks, because, you know, if someone wants to apply for trademarks everywhere in the world, that again is a very high cost. And this has to be renewed every 10 years. So usually it is about signing non-disclosure agreements with companies that would have an interest in investing, or individuals that would have an interest in investing, and this is how they would usually go about that. And then they start registering rights.
Perfect. Okay, so I think that concludes our questions. I just want to say, absolutely amazing presentation. It's so complicated, but also so interesting and so useful to find out about all of those caveats. I'm sure for many of those of you who are watching, you'll find it very interesting, especially if you're in the field, you're planning to create something. You obviously don't want to infringe on anyone else's rights. You want to know what rights you hold. So I'm sure many of you found this really interesting. We had a thank you from Angela. Okay, that's perfect. So yeah, thank you everyone for attending, and do remember to join us for our 2 remaining talks tomorrow. And yeah.
One last thing, Christian, before I go, thank you very much for inviting me. One thing to say for people who are interested in developing something themselves, the moment that they have a very good idea, they have to start thinking a little bit more about it. One of the best tips that I can give today perhaps is not start disclosing a lot of detail on your very bright idea with others without having signed a non-disclosure agreement, especially with patents. If you have found a fantastic invention, you might just be ruining the novelty of what you have just discovered. So this is probably the best tip that I can give. Sign non-disclosure agreements. Be sure that the information that you're sharing is going to be shared in the most confidential way. And the second step, if you have found something tremendously interesting, find an intellectual property lawyer, because many people have made a good life by holding strong intellectual property rights. And sometimes you just need a lawyer to help you build this kind of framework around your own innovative ideas. And thank you very much for having me here, Christian.
Oh, it was my pleasure, and I'm sure everyone else enjoyed it as well. So yeah, thank you everyone, and we'll see you in our next talks. Thanks a lot in a bit.